case is remarkable for many reasons, also remarkable personally to me. For students of law, it would be remarkable because there is hardly any aspect, any crucial aspect of criminal law, procedure and the law of evidence, as well as special statute, where it is located in the larger scheme of things. There is hardly any aspect of this which is untouched by this case. It is also a very, very interesting narrative of investigative procedure. From the point of time where the trial court convicted all four who were put on trial for this case and handed out 3 death sentences to the Supreme Court, where 3 were acquitted totally of terror charges and there was only 1 conviction. You can imagine the analysis, counter-analysis, correction and arguments that must have taken place between the trial court and the Supreme Court. But I will begin on the 12th of December, a day before Parliament was attacked, because personally to me it is significant. On the 12th of December 2001, I had just finished arguing the Tada appeal of Devendra Pal Singh before a 3-judge bench of the Supreme Court. As hearings went, I was very pleased. I appeared for Devendra Pal Singh. In fact, the bench was asking the state very awkward questions. It's the same Devendra Pal Singh about whose death penalty there has been so much news, and finally it was commuted, I think, last year. He was also unwell. And I had more or less thought that the case was in the bag for me. The hearing concluded around 4:30 in the evening on the 12th of December, and I had decided to take the next day easy. And as I was strolling past Shankar Market, I heard from the shopkeepers that Parliament had been attacked. And my first feeling was, right then and there goes Devendra Pal Singh. And true enough, Devendra Pal Singh's judgment, although the senior most judge actually acquitted him, saying that there was no evidence. The only evidence against Devendra Pal Singh was a confession which had not been corroborated at all, a Tada confession. The other 2 judges who upheld the conviction and also upheld the death sentence given to him by the Tada court referred to this kind of things that were happening in the country, more especially the Parliament attack, saying that these were cases where proof beyond reasonable doubt cannot be made a fetish, and a confession, if voluntary, should be taken to be truthful without independent corroboration. For those of you who are students of law, you must realize that there is another reality to the legal process which cannot be comprehended only by looking at the statute or looking at precedent. There is a politics that is going on, and as luck would have it, while upholding the Pota confessions in the Parliament attack case, great reliance was placed on Devendra Pal Singh's judgment. So this is a curious dynamic that takes place. Personally, for me, it was a very it's unforgettable and often enjoyable experience. For one, I had the opportunity to spend a lot of time with KG Kandabiran, no more with us, but he was here at the trial and he appeared for Shaukat, and his was always riveting and a company full of humor. This case was also remarkable for the outpouring of brilliance The kind of people who stood up for the accused in this case were Shanti Bhushan and Ram Jethmalani. The important thing for them was not merely that, whether they personally thought somebody was guilty or innocent, although I'm sure that entered into it in a way. But this was the first Pota trial. We had had a background of fighting against Tada, and to re-establish due process in those difficult times was very, very important. So we saw the likes of Ram Jethmalani and Shanti Bhushan in the matter, who gave everything to it. Shanti Bhushan, I know for a fact, spent 16 hours a day because he was so passionately involved in the case, rejecting all other briefs and concentrating on this. And I have no doubt that his arguments against the manner in which confessions are recorded by police officers had a great deal to do with the fact that eventually the Supreme Court discarded the two confessions in a case like this. Now, what was the Parliament attack case? On the 13th of December, 5 men in a white ambassador went past the Vice President's gate into Parliament. One funny thing is they had a sticker which looked like a Home Ministry sticker, imitated a Home Ministry sticker, but it had some strange words on it. It said, "We hate all Indians, India is a very bad country, BED, the idiot, EDIET, Vajpayee, WAJ, etc., etc., we will kill them," words to that effect. But this car with the sticker was allowed to pass the Vice President's gate. And there was some kind of a scuffle, the security men were alerted. The result, all these 5 were gunned down. There were 3 bodies outside gate number 5, 1 body outside gate number 1, 1 body outside gate number 9 of Parliament, and a huge, amount of explosives were eventually recovered. The local police, as well as the special cell, this happened around 11:30. The local police and the special cell came there around 12:30. An FIR was registered at the local police station. The white ambassador car, because it was flashed on TV, a certain person who had originally owned that car showed up at the Parliament Street police station saying that he was the original owner, and he had bought it from a number of people, and he had in turn sold it to a few people. The investigation began with 2 crucial leads for the police. One is all the dead men had cell phones. The second, all of them had identity cards of some Zansa web city, which was later found to be a fake institute. Or there was an institute, but these people had nothing to do with that institute. All of them had one number, 984411489429, I still remember the number, as the contact number. So what the police did was immediately check the call records of that number, and they found that the telephones found on the dead people had been in touch with this number, and this number in turn had been in constant touch with 2 other phones just around that day. So they put the other 2 phones on surveillance. According to them, one of them was SAR Gilani's and the other was Shaukat. So that was the beginning. But there are a few things which still remain unexplained about the phones. For instance, some very strange thing. In the middle of that scuffle and that fight and that shootout, it appears that 2 of the men who were shot dead, the intruders, were changing the SIM cards in their phones just during that period. And for what purpose, nobody understands, because there was body of the phone, the IMEI, showing 2 different SIMs around 11:29, 11:39 between that, and because both of them were brand new SIMs, none of them had expired. How anybody had the time to do this of course remains unexplained. The other thing for which we still don't have an explanation is this SIM number of Afzal, which was eventually attributed to Afzal, 9811489429. They brought a witness to say that he had sold the SIM card to Afzal on the 4th of December 2001. But in the call records brought by the police themselves as evidence, this number was shown to be in operation even in November, late October, November 2001. This has been brushed aside. When I come to one aspect of the matter, which is expediency versus rule, sometimes courts do tend towards investigative expediency. Some answers are not forthcoming. Whether they are crucial, whether they would make a difference to the case itself, is not easy to say. But some of these things are brushed aside in matters like this. So then, the surveillance of these two telephone calls with which that number on the identity card, I must tell you that that SIM was never recovered. 89429, the SIM which they said belonged to Afzal was never recovered. But call records showed that phone as having been in touch with two other numbers, as I said. So it is the claim of the police that these two phone numbers were put on surveillance. There was a conversation which one of those numbers had with somebody in Kashmir, which they said was Jilani's number. Jilani's, of course, was a registered number, and he accepted that number. The other telephone conversation was of Shauqat's wife with Shauqat. And according to the police, this is what led them to Jilani and Shauqat's wife. And on Shauqat's wife's information, they reached Shauqat and Afzal in Kashmir. But the story did not turn out to be as straightforward as the police wanted it to be. For one thing, you see, quota, unlike many other laws, had a whole chapter on interception of telephone conversations, and in my view, it was a good thing. The general law in India until then was that telephone conversations are relevant to a proceeding, provided to establish the identity of the voices to the satisfaction of the court, and to establish that there was no tampering. So it was a broad general rule on the admissibility of intercepted conversations or telephone conversations. The identity of at least one of the speakers, and that the tape, if it was a tape recording, was tamper-proof. Quota had a whole chapter on interception of communications, and in fact it said that if the specifications in that chapter were not followed, the intercept would be destroyed and would not be used in any court of law. That is, within 10 days of being tendered in evidence, before being tendered, at least 10 days before being tendered in evidence, the origin, the authorization for the intercept and the genuineness would have to be established, would have to be put into court, otherwise the conversation intercept would have to be destroyed. It also had provision, section 43 of quota, also had provision for emergency interception, because they realized that the whole statute was on terror, so they realized that there can be an immediate, there can be an emergency, there can be urgency, and you may not be able to wait for the Home Secretary's permission. So there was a provision to get a here and now authorization for interception. None of this was done. So two bits of conversation were brought in with the charge sheet, saying this is Jilani's conversation with his brother, where he's supposed to have said something like, "Ye Delhi mein kya hua, ye chhe zaruri," or something in Kashmiri. And the other is a conversation of a woman with a man saying, "Do bande aaye the, kahan ho, kaise ho, chotu," etc., which according to them was Shauqat's wife talking to Shauqat. This, in the interim, the Delhi High Court held on this very count to be inadmissible because it did not conform to quota. The Supreme Court said no, the whole thing can be seen again at the trial. And in the eventual analysis, these telephone conversations were both read by the Supreme Court. It is, in my view, another concession to expediency. But as in the event, as things turned out, they felt that the conversations, even if read, did not impute any criminality either to Shauqat's wife or to Jilani. That's a little matter. But it does give an interesting insight into when you want to record confessions by the police, then you impose quota. But when you want to intercept conversations, when you want to, is it correct word? When you want to intercept conversations, you choose not to apply quota, and the argument was we had not applied quota on the first day, therefore we were not required to conform to any of these requirements. That is a paradox, and that is in my view, an unfair position to take. The other thing about these conversations, one of them, the entire tape was for 78 seconds, whereas the recorded conversation was only for 40 odd seconds. And there were other conversations on that tape which nobody explained, which is one reason why the High Court said this is not reliable, but the Supreme Court overlooked that also. But as I said in the event, they considered it to be, they did not think that there was anything criminalizing. So the order in which the arrests were made according to the police was, they taped these conversations, they checked out that one of the numbers was a regular Airtel subscription, namely Gilani, so they arrested Gilani from his house on the morning of the 15th, and then they arrested Shaucat's wife, and from Shaucat's wife, whom they arrested around 1:30 in the afternoon of the 15th, they got information that Shaucat and Afzal were in Kashmir, and based on her information, they arrested Afzal and Shaucat near Sopore in Kashmir. But in this story too, there were several gaping holes. One, they claim to have arrested Shaukat's wife Navjot around 1:30 in the afternoon of the 15th. She is supposed to have been the source of the information about the whereabouts of Shaukat and Afzal. However, Shaukat and Afzal had been arrested early morning that day around 10 o'clock, several hours before the police even claimed to have reached Navjot's family. So this is the investigation in a case of this nature, which is also one of the reasons why there were so many activities. Having arrested them, what was the brunt of the police case? There were two quota confessions. Many of you are students of law. I want to tell you, perhaps you know yourself, that traditionally under the Indian Evidence Act, no statement made to a police officer is admissible as evidence. Not of an accused, not of a witness, not even police statements. It's all out, it's completely inadmissible in evidence. An early departure was made in the NDPS Act, I'm not getting into that now. A significant departure was made in Tada when a confession recorded by a DCP would be admissible against the accused as well as the co-accused. There is a history to this, I'm not currently getting it. Quota retained that provision as far as the accused, the maker of the confession, went, but did not extend it to the co-accused. This is as far as the special laws were concerned. When Tada was challenged in the Supreme Court, the Constitution bench, by a majority of 3-2, upheld this provision of police confessions. Two judges still said this is completely unacceptable in the Indian context, but the majority did so. I don't know, once they uphold it, I don't know whether the word reluctantly makes any sense, but there was a degree of reluctance saying yes, but we must trust our own policemen. After all, in other countries, in the US, in the UK, statements to police officers are admissible. Why should we not have it, particularly when the country is going through terror and all that, and this is a special provision that is needed. But two judges still said this is unacceptable. The violation of Article 21, violation of the Equality Clause, and the police can't be trusted in terms of confessions that they record in cases they are interested in prosecuting and securing a conviction in. Now, compelled self-incrimination is what is outlawed by the Constitution, not all self-incrimination. Compelled oral self-incrimination has been outlawed by the Constitution, but there was an implicit understanding that when the police brings a statement as a self-incriminating statement, a certain compulsion is virtually read into it, deemed to be compelled. This was slackened in Tada with the consequences that I mentioned, but because there was an outrage. Actually, the Indian judicial conscience has always been extremely uneasy about police confessions. They have upheld it, then those laws have been repealed or they have lapsed, then again they try and recognize it. It's a very, very uneasy. It's not as though they are able to wholeheartedly accept it. On the other hand, they sometimes feel impelled to permit them. But clearly it's on an understanding that there are strong arm methods used, and without these strong arm methods, perhaps you cannot control terrorism. There is that uneasy feeling. On the other hand, there is also much heart searching over it. This is the way, we have taken many tosses and turns with this. But Porter restricted this to the co-accused without having the words which Tada had, and as against any co-accused, conspirator, etc., tried in the same trial. Now, the regular law of evidence also permits statements of co-accused, confessions of co-accused, although they don't have the status of evidence, section 30 of the Evidence Act. But they may be taken into consideration. So the traditional law is it does not qualify as evidence under the Evidence Act. No conviction can be based only on the confession of a co-accused, but if there is other evidence which, if believed, would lead to a conviction, then to get that additional assurance, you may look at the confession of a co-accused. This was the traditional position. So an interesting legal question arose in the Parliament in that case. First, whether the absence of the word can be used against co-accused, conspirator, etc. You must tell me if I am being too dense. Whether the dropping of those words was significant as statutory intent to keep these confessions out of operation against the co-accused. And assuming that to be so, would these confessions then be at least as relevant as they would be under the normal law? It was a very, very interesting question. In the event, the High Court and the Supreme Court both categorically held that the statute meant not to use this, and if it was not to be used, it was not to be used in any sense. You can't go back to the normal law of evidence to try and bring it through the back door. This is a very, very, very significant opinion. Both of the High Court and the Supreme Court, they were unstinting in their opinion that this could simply not be used against the court. The play of special versus general came up in several ways in this case. One is how to interpret this special law on confessions with newer wording, more truncated wording. The other thing was, you have a general law of conspiracy. Under the Indian Penal Code, a conspirator can be in most circumstances punished in like manner as the main actor. 120. Porter had a main section who said whoever does any act or thing, it had 3 requirements: whoever does any act or thing with a certain intent of either undermining Indian security, sovereignty and so on, or to strike terror in a group of people, with the result. So there was an intent and there had to be an act, and that act had to have a certain result for it to be a terrorist act. Then there were other sections for aiding and abetting such an act, conspiring to do that act, facilitating such an act. So 3.1 was the act itself, definition. 3.2 was punishment for doing that act. 3.3 was aiding, abetting. 3.4 was harboring, and so on and so forth. So on the one hand, you have the law of conspiracy, where the conspirator for the mere fact of conspiracy can be punished as the main actor. Then you have Porter, where the main actor, there is a specific punishment. It could be death if death is caused, or life if there is destruction of a certain order. And then you have a separate section punishing conspiracy. So the question arose in Afzal's case, since he was not on the spot, he did not do any act, can he be treated as having committed the terrorist act which of course resulted in the death of 7 persons. So if you believe that, so death was a competent punishment for that act. Or because he was not there on the spot, whether it, so can you say that that 3.1, the 3.2 will not apply to him and he was a mere conspirator for a terrorist act? And if he was a conspirator, you punish him under 3.3 of quota, where the maximum punishment is only life? Or can you fall back on 120B to say you must punish him as the main actor? This is another extremely interesting aspect of the case. And the Supreme Court eventually, by a very interesting piece of reasoning, said no, you have a special law, you have it for the good or for the bad. If you have the special law, and they also said because you have a special law, you have truncated due process. So if the law says conspiracy can only be punished with life, then a person who was not present and did not do any act or thing cannot be treated as the actor, can only be punished as the conspirator. Then you can't fall back on the general law to impose the death penalty on him. So in two significant ways, the Supreme Court said once you have said the general law is ousted, what is sauce for the goose is sauce for the gander. So you ousted the law of evidence to bring in police confessions, then you can't fall back on the law of evidence to bring what the statute does not permit you to do, either by way of reading it against the co-accused or by way of imposing the death penalty. These two, this aspect of the Supreme Court judgment is something I would want every student of law to read. Not merely because I agree with it, but because of the discussion of the case law and the discussion of the syllogisms used, the examples used are very illuminating. Now, having said this, nevertheless, when it came to the question of interceptions, the Supreme Court said, because what was the specious argument for not following quota on interceptions? They said, just then such a huge thing had happened in the FIR, we had not added quota. So since we had not added quota in the FIR, we were not obliged to follow the requirements of quota with regard to interceptions, which we had to carry on that very day. But if ever there was a terrorist act, this was one. I mean, there was nothing hidden, or there was nothing, secret, or there was nothing so. It was not a conclusion that you had to arrive at with some extremely sophisticated reasoning. If ever there was a terror act, this was a terror act. So, and there was a quota ordinance then. The act only came in March, but there was a quota from October 24. So you had an ordinance which permitted interception, emergency interception. You choose not to follow that act. You choose not to, and the argument was we had not added quota in the FIR. Why? Because it's such a draconian law that we had to think before adding it. We did not want to, so this, they tried to make a human rights argument for this, which in my view was absurd. Because you use quota, you record confessions. So when you want to record confessions, you add the section. But when you have to follow something, you don't. Anyway. But anyway, this argument was upheld eventually in the Supreme Court. But the High Court, as an interim measure when the trial was going on, we challenged these interceptions, saying they are not in accordance with quota. And we not merely, see, one thing is, this is something I want you all to think about. With the kind of technology you have, anybody can virtually tape anybody without knowing that whether it's Amar Singh or somebody. Everybody seems to be able to tape everybody else. If you cannot govern this by technology, is it worthwhile at least governing it by ruling it out of use? What is the point of having a procedure for interception if material can be brought into court even without adhering to that procedure? Is a question that's well worth thinking about. There are of course judgments of two kinds. It's a different thing. It's a detailed legal discussion. One is even if illegally procured evidence, if relevant, can be used. That is one stream of cases. The other is where guilt itself depends on a certain possession. Then if there is any statutory prescription about search regarding that position and that is not followed, such as in drug cases, then that evidence cannot be used. In any case, our early success in having this entire thing declared illegal interception, that advantage was lost because eventually the Supreme Court read it, but as I said, that it was not, because the nature of the conversation was such ex post facto that it did not necessarily lead to the inference that people who had spoken knew what was going to happen to Parliament. So on that extremely strict reasoning, 3 of the 4 were acquitted. Before I come to Shaukat acquitted, because there's a common misunderstanding that Shaukat was only given a reduced sentence. That is not the case. Shaukat was acquitted of all terror charges and he was convicted for concealing the design to wage war in India. This waging war, the discussion on waging war in the Supreme Court is also worth reading, because there are riots, there are demonstrations, there are violent demonstrations, there are political demonstrations, there is political violence, there are terrorist acts. Do all of these ipso facto automatically constitute waging war in India? There's a very interesting discussion tracing the law from the late 19th century or mid 19th century about what was the original British concept of treason. That is, the person of the regent, the person of the king had to be protected. Then what was the colonial understanding of waging war? Then there is a very, very interesting judgment of 1951, although given by a British judge who was still in office, about a mutiny in Bihar, which happened, I think, in 46 or 47, where the reasoning was, it is not merely the amount of arms or the manner, why have people assembled is the issue, where the mutineering policemen caught hold of the armory and fired at the forces when asked to surrender. The Patna High Court in Mir Hassan Khan held even this is not waging war, because unless you have the intent to seize state power or seize any aspect of state power, mere potency of violence or nature of violence is not sufficient to render something waging war on the state. So there is a difference between insurrection, terrorism and waging war, which the Supreme Court recognized. However, they said that this particular act did amount to waging war because the purpose was to strike at the essence of Indian sovereignty, namely the Parliament. But not every terrorist act would automatically mean because you're questioning the states, therefore waging war. But this particularly, because if they had seized control of the building, or if they had taken hold of the legislatures, parliamentarians, and if they had dictated terms to them, then it would be virtually like directing state power. So it is the choice of the attackers that led the Supreme Court to believe that this was waging war. And concealing waging war, and in a strange circle, the trial court, which had originally, now there were 4 accused actually, I have not spoken systematically, I should say. There were 4 accused because the 5 died. So through these telephone conversations, they reached Afzal, 89429, Shaukat, Jilani, and Shaukat's wife. So these were the 4 who were put on trial. The trial court, when it was even charges were argued, saying there is really nothing against Shaukat's wife other than this conversation. Trial court had framed an alternate charge, either the regular charges of photo, waging war, murder, etc. Alternatively, the intent to conceal the design to wage war. She was eventually convicted only, and she was acquitted of all other charges, convicted only under this design to conceal the waging of war, given 5 years. Eventually, she was acquitted both by the High Court and the Supreme Court. But as events turned out, in the ultimate analysis, the Supreme Court acquitted Shaukat of all other charges and convicted him under this section 123, saying everything about him, that he was moving around with Afzal was explainable because they were cousins. That he was seen at various places, but he had not ever, there was not one telephone call between the deceased men who were killed in Parliament House and Shaukat. He was not seen anywhere buying weapons, procuring anything. His movement with Afzal could be explained by the fact that they were cousins. There was a probable explanation, and there's a very, very detailed discussion of what is circumstantial evidence. In any circumstance that may not be one raised by the accused, but if it's consistent with his innocence, then that should be there. So he was eventually convicted. Of course, again Mr. Shanti Bhushan challenges, saying he was never charged with this offence of concealing. So this was not an offence which was a minor offence. There is a notion of a minor offence contained in a larger charge. I'm not getting into that. But that is what he was convicted of. In the discussion now, the evidence was of two kinds. One, two confessions, quota confessions of Afzal and Shaukat, in which there are stray references. Jilani also said this, and Shaukat's wife was also aware of what was going on. Then there were recoveries. They said Afzal, three things. They said Afzal recognized the dead men. Of course, this is a controversial thing because up until the Parliament attack case, any statement to the police in custody, including that of identification, was ruled out as evidence. But the Supreme Court held that Afzal's so-called recognition of the four dead men was admissible. So to this extent, the Supreme Court has deviated from precedent until then. Then there were shopkeepers and others who remembered selling cell phones. I told you one of them was slightly suspicious because he said he sold it in December, whereas the phone had been in use in November. Then there were people who had sold silver nitrate powder, and a man said that he remembered because it was such a large quantity. Then the police case was that there was a mixer grinder found in Afzal's house which had pieces of explosives, and the landlord who had housed these five men who died, who claimed to have seen Afzal with them. So this was the nature of evidence other than the confession. On the confession which had been accepted by the trial court and the High Court, although the High Court said that they could not be used against the co-accused, which is why the High Court acquitted Jilani and Shaukat's wife. The Supreme Court really had, in fact, that it is a complete indictment of the wisdom of police confession. You must read the judgment for that. In a case of this kind, Justice Vidhi and Justice Navjot said, why police confession? When you have a magistrate, and according to you a person is willing to confess, and that provision is there, why police confession? And they dealt with this logic of how in other countries they have confessions to police officers admissible as evidence. Why not in India? Was answered by saying certainly not in India, because given the track record of the police, given their the human indictment of human rights groups of police behavior, they certainly cannot be trusted when it comes to confession. And the court said, well, a larger bench has upheld these provisions, so we can't say anything about it, but we would think this extremely unwise to give the police this power of recording confession. This was in fact quoted in Parliament when there was a demand to bring in quota-like provisions again, and which is why in the UAPA there is no provision for police confession, but there are other laws in India like Makopa which permit that. The interesting discussion on confession, the Supreme Court said there was very, very stringent tests. One is that imported Miranda-like standards into this. Said if you are not given your custodial rights, then you cannot rely on a confession made in custody. Those custodial rights are not only what have been specified by the Supreme Court in D.K. Basu, but there are also statutory rights both in the CRPC and in quota, that is right to access to a lawyer, right to have access to the family, legal advice, a whole lot of these things which the police frankly admitted. They said we never told them that they had any right to consult a lawyer, we never told them they could meet their family. he never told them any of this. The Supreme Court said in the absence of this kind of compliance with custodial rights, the confession would become suspect. Second thing is, POTA has this requirement that, it's a strange requirement, you don't take the man to a magistrate. Although even magisterial confessions are really, the way they are recorded and the truth that emerges from seeing judgment after judgment of magisterial confessions, I would have issues about those too. Any self-incriminating statement by which an accused does not stand at the trial, in my view, should not be used. But that's my personal view. POTA said as soon as a confession is made, the confession along with the accused must be sent to a magistrate, and if the accused has any complaints, he should make it to the magistrate. So the Supreme Court asked, and rightly, if you are willing to take him to a magistrate afterwards, why did you take him straight away to a magistrate to record the confession? Where is the need for all this rigmarole? Now, the Supreme Court recognized that continued police custody will make a person balk at telling the magistrate that he did not wish to make a confession. This is quite sympathetic to reality. What is the situation in custody? Whether such a person would speak out at the trial before the magistrate saying he confessed under pressure. But if he was to go back to police custody, then he's not going to speak out before the magistrate. So they ruled out Shauchat's confession on just this ground that he had no access to a lawyer, he was not told by the magistrate did not assure him that if he spoke out he would not be sent back to police custody. Therefore, the fact that Shauchat did not even tell the magistrate that this confession, so-called, was under pressure, could not be used against him. Likewise for Afzal. So both Afzal and Shauchat's custody confession were thrown out by the Supreme Court. So there were three levels at which the Supreme Court objected to the confession. One, lack of custodial safeguards, like access to a lawyer, etc. Two, what they considered was inadequate compliance with the requirement before the magistrate, particularly as to police custody, assuring him that he would not go back to police custody. These, they said, were completely, non-negotiable. In addition, they said that the tone and tenor of the confession, which also we challenged, we said, which man? Shauchat's wife was expecting a child. There is a confession saying, quite unnecessarily, my wife was in full know of everything. So the argument was, which man would voluntarily drag his wife's name into a confession? If it was voluntary, this is unlikely to be part of that confession. All these unnecessary details indicating A, indicating B, etc., etc. So the Supreme Court said these were all very weighty arguments, but because they were throwing out the confessions on violation of statutory safeguard, they were not entering into this. But as a scheme, if you look at that judgment, it's a complete indictment of the manner in which the police record the confession. One, they have no access to lawyers. Two, they have no idea, they can't speak out against the confession because they don't know whether they're going to go back into police custody. And three, what is put in the confession can also be looked at by the court to say, is it likely that such a confession is truthful? Is it likely that such a confession is voluntary? And they restored the twin tests of a confession which had actually collapsed into one during the Tada years, Lasting and others, that a confession has to first be voluntary. If it's established to be anything other than voluntary, it has to be thrown out. Even if voluntary, it has to be truthful. Now how, when you look for truth, there has to be some broad corroboration in material particulars. Of course, I don't think that it is followed as scrupulously as it ought to be. But after having said all this, the Supreme Court, of course, there may be a particular case in which a man may be sent back to police custody. So some of these dilutions can be confusing for lower courts. The other two or three aspects I just want to touch on. One is electronic evidence In this country, there is absolutely no clarity and no discipline how electronic evidence is to be preserved, how computers. Now, the laptop they say they seized from Afghan. It was lying in this special cell, and some fellow down the street who sold computer parts was asked to come and look at it and give a report, and that was the first report, and after that it was just lying the way it was lying. The idea that data is all mutable was not fully clear even to the judicial authorities dealing with the matter. In the event, the CFSL was asked to look at it nearly a month later. The file showed that the computer had been accessed on the 18th of January on a day when it was supposed to be lying in the Malkhana. This was pointed out to the Supreme Court. But as I said, in some aspects of the matter, expediency in the matter like this, somebody must have just checked it. You see, there is no somebody must have just checked it, because every access to incriminating material, mudda mal as it's called, must be explained, particularly electronic material, because almost everything on a computer is text editable. So evidence was left to show this. So on aspects such as these, on aspects such as confession, how to appreciate a confession, the Supreme Court really, made quantum leaps. On an understanding of the special law versus the general law, as I said, that when the special law itself restricts something, then you can't fall back on the general law to expand that scope to the detriment of the accused. The Supreme Court was categorical. In, however, recognizing certain investigative expediencies, such as they did not comply with quota procedures for interception, that aspect was not taken as seriously as we would have liked the court to take. On electronic evidence also, the Supreme Court said you have to prove that there was tampering. That part of the Supreme Court judgment has now been overruled in a later case, saying that the certification under Section 65B of the Evidence Act of Electronic is absolutely mandatory. Some aspects of regular criminal law have been diluted, like identification while in custody. Afzal's identification of the 5 terrorists is after all a custodial statement, but that was used against him. Then on what is discovery and pointing out, this is of course the last bit, then I finish and you can have questions. See, all statements to police officers are ruled out at the threshold. However, Section 27 of the Evidence Act says if a fact is discovered pursuant to a statement made by an accused in custody, so much of that statement which is attributable directly to that disclosure can be led in evidence. So this is as far as discovery goes. Independently, there is a provision under the Evidence Act, Section 8 Evidence Act, which says the conduct of an accused is relevant. Conduct of a party to a proceeding, that includes an accused. Somehow this conduct has come to mean a very strange notion called pointing out. So they say an accused in custody is pointed out to something. So he points out to a place and something is recovered from there. So pointing out is very, very dangerous, because it does not have the safeguard of Section 27, that there is a statement and somebody has to stand up and say this is what he said, it's in pursuance of this that I have discovered, this is not required. This pointing out is, does somebody just come and point like that? It is pointing out how it has emerged. It's very, very strange. But there is a 1987 judgment of Justice Chinnapareddy, which in my view is what has led to this extreme widening and the blurring of the distinction between a discovery and pointing out, saying that even if the accused does not record a statement leading to a discovery, the fact as spoken to by a policeman that he pointed out to something is nevertheless relevant. In my view, that runs the danger of disguising a coercive recovery, or even a recovery which may not be attributed to an accused, which may not really be from the accused, as something which can be attributed to an accused. So this various shops that Afzal led them to shop A, shop B, the explosives where they got silver nitrate powder, etc., etc. That a policeman says Afzal led me to the shop, as corroborated by the shopkeeper, has been treated by the Supreme Court as a pointing out. This does have, in my view, although the Supreme Court relied on earlier judgments, this has some dangers for custodial coercion or at least manipulation of record. But as I said, this is not, the Supreme Court merely expanded on an earlier judgment. I have found time and again in Gujarat, I've seen cases, but there is no evidence. They just say the accused pointed out, this is the hotel at which we sat and hatched a conspiracy. What kind of evidence is that? The hotel is anyway there. So this is really the policeman setting up a story saying the conspiracy was hatched there. So this pointing out is a pernicious thing. And all the evidence that says the conduct of any party is relevant. So for it to get magnified into this pointing out, as a criminal lawyer, I have found it capable of great misuse. Then the traditional view that there cannot be joint disclosures, if they attribute joint disclosures to two accused simultaneously, then it cannot be evidence against either, were diluted by the Supreme Court in this case. In some cases, it may be possible to attribute it to one or the other. So there are some aspects of criminal law which I feel have been some safeguards which have been slackened, others have been tightened. So the law on conspiracy, the law on confessions, the law on waging war has been greatly clarified. Law on circumstantial evidence, that all of the two courts have sentenced him to life, to death, and the Supreme Court held Shaukat completely innocent. Please don't go away with the impression that merely his sentence was reduced. He was acquitted of all terror charges, all conspiracy charges. Yes, he was convicted of concealing the design to wage war, implying that he knew that something was afoot, even which we challenged, saying he was not charged with it. So circumstantial evidence, Supreme Court is very, very stringent. But some other aspects of criminal law, I feel that was really a concession to expediency. Afzal was sentenced to death for murder and for waging war. But under quota, the two sentences of death of the trial court and of the high court were removed by the Supreme Court. He was only sentenced to life. Of course, I mean, that small comfort if he was to be hanged eventually, that's a different matter. But legally, it is significant. I think that's all I have to say. If you have any questions.
Thank you very much, ma'am. We'll now open the floor for questions.
Ma'am, you said that this pointing out has been included as within the ambit of the conduct of the accused. But right, a lot of cases say that gestures will amount to a statement, particularly, for example, tying declarations as well, when the victim is unable to make a statement. How does the state justify this divergence, wherein you already have an extremely well-established body of law that says a gesture will be a statement, and the statement itself is covered, is protected under the law?
See, that is gesture may be a statement. Many things are statements, but only some statements can be used against the accused. So what might be legitimate to read into evidence when it emanates from somebody else is not something which can necessarily be read against somebody whose liberty is impaired. So after all, a statement made in police custody is also a statement. But law says this will not be used against the accused. So there is a difference. I am not saying because gestures cannot be statements. I am saying it's dangerous to use that against a person. Dangerous because if a person can be convicted on a supposed gesture of which somebody else speaks, and a dying declaration, is an exception. It's an exception to the hearsay rule because the person is not there. So that there is a gesture can be used in any number of, it is conduct. I'm not, in fact, Section 8 says statements will not amount to conduct unless they accompany a gesture. So that's the difference. I'm not saying gestures per se are out of evidence. I'm saying without relying on the safeguard Minimal safeguard that leads in section 27. To say somebody pointed out to something incriminating, which would become a pure and simple statement of a police officer saying something was done in his custody, has dangers for an accused. That's what.
Ma'am, I understand that and I agree with you. What I'm asking is, how does the state justify this? Because it seems like a completely bogus distinction.
The state, because many judgments have dealt with section 8 as a pointing out, but the one which really kind of brought this theory into its own was the Prakash Chand case by Chinnappa Reddy, saying even if it does not amount to a disclosure under section 27, it may still amount to the accused pointing out. There are judgments of, I think there's a full bench judgment of the Allahabad High Court. It was either Sir Ashutosh Mukherjee, I don't remember who it was, who said that joint pointing out is also not permissible. That pointing out, the Supreme Court also tried to say that there is corroboration from the other side. He points out to a shop, this should not have been previously known to the police. So all the principles that apply to a disclosure under section 28(7) are supposed to apply to a pointing out. But in which case, why have a pointing out? Then why not have a disclosure? Because section 8 does not speak of pointing out, it only speaks of conduct. So it speaks of conduct, for instance, the fact that as soon as the police came, somebody broke into sweat is considered relevant. So physical, or the fact that somebody ran as soon as they said chori ho gayi, police aa raha, and the fellow ran, it's considered relevant immediately. Some are res geste, some are whatever. So conduct is relevant. I am saying the conduct of the accused is also relevant. See, criminal law is not meant only to safeguard the accused. It's also meant to reach the guilty. But a pure and simple, once you find the police unreliable on most counts, then to rely on the police saying something was pointed out, which I have not reduced to record by way of a disclosure, has dangers, especially pointing out to dead bodies. Saying he told me this is the name of this terrorist, and Afzal, because Afzal said yes, I knew this Muhammad, but I didn't know the others. At the trial, that's what he said. So the man is speaking. After all, a person who says I know A, but I did not know the other four. You rely on a custodial pointing out on the other four. He also said yes, I bought the car. He interrupted his amicus to say no, the witness is speaking the truth. Afzal actually displayed some remarkable qualities which I saw personally. Perhaps this is not the place for it. And was exceptionally considerate, very human, would ask after our health. I thought that he showed very, very human quality. I cannot comment on his guilt because I did not represent him. It would be improper for me to speak about that. But what I'm saying is, to say somebody pointed out, how the hell is somebody to counter this? If the police says in custody, she told me, she points to something and said this is what, really the law is not that. Even the law on pointing out as it is now can be differentiated. But courts do fall into the danger, especially trial court, to believe in this kind of a pointing out, considering the Evidence Act does not talk about pointing out. This coining of this pointing out, I personally think is problematic. It's not for the state to justify. It's like courts have time and again recognized it, and that's how it has come into the manner of judicial and police function.
Ma'am, just.
Ma'am, you pointed out that part of the parliament case was subsequently overruled. What do you think is the consequence of the same on the culpability of the accused in the main case?
See, when a conviction is overruled, there is only one consequence for the culpability: they are acquitted. So the trial court's verdict that all four were guilty, 3 of conspiracy and 1 of concealing waging war, was overruled by the High Court to the extent that Jilani and Afshan Guru were acquitted totally, but the other 2 convictions and death sentences were maintained. The Supreme Court further modified it by acquitting Shaukat of all charges other than concealing, and retain the culpability of Afzal and sentence him to death on 2 counts. So it's not my thinking, what the consequence of the culpability is known.
My question is really specific to the case, but it also hits at a larger principle. So when, like, you pointed out a discrepancy in terms of the police reporting that they picked up Navjot Sandhu at a particular time, but in reality they'd arrested Afzal Guru and Shaukat earlier. My question is that anything that is recovered after that becomes dubious, right? But we don't have a doctrine of like the fruit of the forbidden tree in India. So what is the usual recourse to the accused in such a case?
There are 2 streams, as I said. One is, though the arrest may be illegal, recoveries can be believed. So, illegal custody may raise a doubt on the recovery but does not render it inadmissible. The fruit of the forbidden tree is limited to, as I said, the Baldev Singh case with the full constitution bench decision on the narcotics. That where the mere possession is an offence, then if there is a statutory prescription about how to search for that possession and that has been violated, then you cannot rely on that. But otherwise, merely because the search is illegal, or the search does not have, after all the CRPC says you must have witnesses, independent witnesses for a search. Even if you don't have that, judgment after judgment says, nahi hai to koi baat nahi. Sometimes they don't believe the search for other reasons, but it's not ruled out of evidence. So fruit of the forbidden tree is not forbidden, except in some circumstances under the law.
There's a question.
We'll take one question from here and then.
Not over. Good evening, ma'am. The gentleman talked about conduct. I have been a magistrate for the last 3 years, and in many cases I've had such pointing out memos. And the prosecutor always relies on the point that yes, it is relevant as conduct under the Indian Evidence Act. But we've construed conduct as something that is at least contemporary with the act, or which has an inference, which raises an inference as to a fact in issue or a relevant fact, and there should be some spontaneity, a continuity in transactions. So something that happened like 1 year after the offence can never be taken to be relevant as conduct within the meaning of Section 8.
I agree with you. But it's not always understood as that. In fact, if you read Section 8, of course it's not strictly res geste like Section the conduct can also be subsequent. For instance, if it doesn't have, there is no time limit. There has to be some spontaneity as to link it with the criminal act, yes. But it does not have to be as immediate as Section 6. But I'm questioning this pointing out conduct for a different reason. I'm saying it's a pure and simple custodial statement which in every other sense would be it either by 162 CRPC or by Sections 25 and 26 of, but there's also this explanation that statements do not constitute conduct unless they accompany the act. So in that confusion, courts have gone in different directions and somehow this pointing out has come to be. Of course, so it has come to a situation where the arrest is 3 months after the incident. The questioning is 1 month after the arrest, and then he points out and says, "Maine yahan se liya tha." Even the law is that there has to be some independent corroboration. If I point out to a shop, that is that Om Prakash case, that I may point out this is where I sold the ring, but the jeweler has independently to corroborate, yes, so and so is the one who sold it to me. It's not as though courts have been singularly irresponsible in upholding this conduct, but it has slackened to a point that merely this pointing out has some confusing attributes which we have not been able to fully control in the manner of interpretation. Spontaneity, yes, but not the same kind of spontaneity as res geste. Even the Evidence Act, to be frank, does not insist on that kind, but yes, really this is information from the accused. But I'm not even sure whether the Evidence Act meant Section 8 to relate to information from the accused. I think it was, demeanor, features, some conduct which may later be considered guilty, like running away, absconding. In my view, that is really what Section 8 was meant for. But suddenly in Indian law it has acquired this pointing out dimension, which is an addition to Section 27. I have a great deal of disquiet about it, and you're right.
Right. and we've been disregarding it or eschewing it from consideration on the point that you cannot make serious inroads into what Section 25 clearly prohibits.
Exactly.
And Section 27 carves out a very limited exception.
Correct.
And it says that the fact that you've got from the mental knowledge of the accused has to be confirmed by physical facts.
Yes,
So that is how
subsequent
you-
confirmation.
Yes, and that is
That
how-
was important.
So that's how the objectivity is there, and something that's basically just information, there's no objectivity to it, and how can you rely on
No
that?
corroboration. In fact, I must tell you that it was sought to be argued by the state in this Parliament attack case that there is something in the custodial statement of, say, Gilani or the Navjot Sandhu. There is something else in the custodial statement or confession of Afzal, and that amounted to subsequent confirmation. It was such an extraordinary thing that one custodial statement being corroboration of another custodial statement. Fortunately, neither the High Court nor the Supreme Court would have anything of it. Saying that they went back to Subkhan and all, that discussion on this is also very illuminating, because although it does not mean only a physical object, but there has to be some physicality to the discovery, which is not only subsequent but pursuant, consequent upon the information, and to that limited extent. So that discussion is there, but in the end, of course, it becomes a little more confused. But if you go back to 1929, or if you go back to cases like Inayatullah, you're absolutely right. There has to be a physicality and independent corroboration. In fact, it is called the doctrine of subsequent corroboration. There has to be independent corroboration. They tried to do that in the Parliament attack case, also saying Afzal pointed out to a shop, and the shop owner subsequently did say that they came and bought it from me. But nevertheless, it's a custodial statement, and once you disbelieve custodial statement, then to extend it is definitely problematic for due process, I would say that.
Right, here.
Over.
It's not stick to the topic that we are discussing, and the act which has tied up for the, like, there was a time when in the times of when the Abraham Lincoln was dead, there was a girl woman called Mary Surratt. At the time, the American government was not to show the legitimacy, they took the judges which favor them. So this act like such a tied up what is it that the capital punishment or the evidence that they required is to just to show the legitimacy of the state to treat the terrorist people, or is to show that the state is empowered to treat every accused or the accused that comes in front of them to kill them or to murder, judicial murder can be done.
Well, there's no doubt that there is a certain amount of hype over nationalism, national interest, nation in peril, so need for special laws, need for cutting down on due process requirements, that much fetish is made of the benefit of the doubt. So this is all part of the discourse, and it exists at various levels, and surely it must be affecting the judicial processes also. Because what happens is, as I told you, the previous day I had argued something, I had reason to believe that I might even secure an act. This, of course, pure conjecture, no judgment had come. But the fact that there is 1, 2, 3, 4, 5 terrorist acts does make a difference to people's notion, not only the statute itself, but how you interpret statutes, how you insist on safeguards. That it happens. If I've understood your question correctly, that's what I think.
There.
This young
Hi, I wanted to ask about the line between waging war and other acts of terrorism that don't constitute waging war. Do you think that in this case the courts have expanded the meaning of what is waging war on India, and that could be a very insidious thing if they did?
Actually, I think that they did not expand it. My personal view is that they did not expand it. And my personal view is that they, in fact, made the subsets, and I mean, they said that many of them may overlap, but there is a distinction between pure and simple exhibitionist acts of terror, constituting a great deal of violence but still may not amount to waging war. But an attack on sovereignty, and not even every terrorist act of a political nature is waging war, but in this case, because sovereignty was attacked, and they endorsed Mir Hassan Khan of Patna saying that there has to be some engagement with state power. The object has to be. So I would not personally say that they expanded the notion of waging war, but certainly they felt that this particular thing, the site of the attack, definitely weighed in favor of the Supreme Court holding that this was waging war. But I don't think they expanded it.
A question over there.
So this is not related to the case per se, but as a lawyer who took part in the trial proceedings, to what extent do you feel that the way the media handled the case coverage at that particular point of time, as well as subsequently when the time of Afzal Guru's, when he was supposed to be hung, and the circumstances under which it happened, to what extent do you feel that media's involvement in shaping public opinion in the reportage of the case and its proceedings actually motivated action in that regard?
I was extremely, with a few notable exceptions, some of them are present here, and there was hardly, it was like during the trial, the media was completely non-critical of the state. In fact, one aspect of the case, I must say, that the investigating officer paraded Afzal on television, saying, this is how we did it, this is how we did it. Even the so-called confession had not been recorded. And he just, broadcast his guilt to the world at large, and the media followed it. We raised this in the Supreme Court. The Supreme Court said it ought not to have been done, but we shall say nothing more. The media originally, I think the media is, by and large, I would say, with a few notable and brilliant exceptions, the media has become rather undifferentiated, uncritical, and non-analytical about many of these cases, which is a disappointment because they don't necessarily have to speak in favor of the accused or whatever. I can also understand anger at acts of terror. Ordinary people die. It is not to be taken non-seriously. In Parliament itself, 8 working class families died. I can understand the sympathy for that. But the state processes have to be under scrutiny, and I'm not sure that the majority of our media understands that responsibility. So even during this case, in fact, some were actually hostile to us, and also were critical of the arguments made against the death penalty, saying, look at the way these people are arguing. After all, if I'm hired or if I'm A's lawyer, I'm not going to stand and say, yeah, hang him, no? So my very duty requires that I question the death penalty, but the nature of arguments that we were made were criticized by the media. That we appeared for them were criticized by some sections of the media. But there were some papers, for instance the Hindu, who at least during the trial maintained a balance, recorded arguments of both sides, but they were the exception rather than the rule. So I have been disappointed in media coverage of many of these issues. Not so much because they're not fair to the accused, that is one point. But you see, especially early on, the only police handouts, so and so has confessed to this, such and such a thing has been recovered by so and so. So there is a public opinion, but of course, there also has to be public opinion. Courts are supposed to be immune to it, but the danger arises when the height reaches a point where lawyers are afraid of representing them. This has happened in Banaras, in Varanasi, and it's not just the media. There have been bar associations saying nobody will defend so and so, nobody will defend such and such. So this understanding that there are serious instances, but people are entitled to a fair trial. That fair trial means, there would be 2 opinions on guilt. These we would have taken as understood, and these distinctions are definitely blurred, and that's not a mature way of being for a society. And the media has been disappointing in some of this. But so have bar associations and so have so many, this is, everybody says, to terrorist ki lawyer, how do you know the fellow is a terrorist until it's established and somebody has to, because what people forget is if you catch hold of the wrong fellow, then the right fellow is escaping. So it's not even, it is in society's interest that these things are properly investigated, properly tried. Judges have the courage to say yes and no to these things, because if you have to just put a stamp on the police case, tomorrow if this is the way the media gets hyped, then judges may be afraid to rule. So it is really not in society's interest that police action is left uncriticized. Because then the danger, apart from anything else, the danger of the catching of the first fellow and saying he has confessed and this is the end of it, means the fellow may actually, this has happened, it happened in Malegaon. For 8 years those fellows were in jail, and it was later found that somebody else appears to have been guilty. I don't want to make categorical statements. So it happens. So uncritical media is of course a severe disadvantage.
Oh, yeah.
Good evening, ma'am. I was wondering a little bit about what you said regarding the use of comparative authority and the point you made that they relied on English authority to decide to rule on the point of admissibility of statements made to the police. And I remember other instances also. For instance, the Marimat committee talked about allowing adverse inferences when there is a violation of the right to silence based on English.
Yeah, I think that's a dreadful idea.
Right, and then in Bachchan Singh, in fact, when evidence was cited from abolitionist courts, then the court went on to say, no, we can't look at that because India is different, like socioeconomically. So, I mean, there is a picking and choosing of when to rely and when not to rely on comparative authority, right? So, I mean, do you think it is possible to make any sensible, generalized observations on the point?
No, you see, there may also be some relevance to picking and choosing. I mean, you can't say that there is no relevance at all. It all depends on the context. No, I merely mentioned it saying for a long time courts have said we should not disbelieve our policemen. So in the Parliament attack case, they went into it. They said if in England, see, Rajiv Dhawan long ago told me this and it makes eminent sense. He said when Stephen was writing the law of evidence for India, but later he said that the law I drafted for India is far superior to the law of evidence in India. See, the idea was, of course, it is twofold. One is they thought the natives could not be trusted, whereas the British bobby could be trusted. But more importantly, in England at that time, you could not arrest until you had indictable evidence against somebody. Whereas in India, you could arrest on suspicion. Therefore, they felt that the temptation for the police to force a confession would be greater in India, apart from the fact that they thought that they were much more civilized, whereas the Indian policemen could not be relied on. I mean, there were many subtexts to this. But the long and short of it was that police statements were considered inadmissible because it was taken as read that there would be coercion of some kind or the other. Which we have to think of it both ways. Now that was diluted because they said, why don't we now trust our policemen? So the Parliament attack case looked at it. They said in the US you have Miranda. The slightest violation of a Miranda safeguard, the confession will go out. In England you have a trial within a trial. So the minute somebody says this confession is wrongly recorded, then a trial has to take place within that trial to ensure that the confession was properly recorded. In India you do not have these things. And therefore, we do not think it is a good idea to have these confessions. Of course, a larger bench has upheld these confessions, so we can't say anything more, but we can only express our apprehension. But I want to say this, that how do we think that magisterial confessions are anymore? Because there is in fact, Mr. Nariman has written that somewhere, that he had this discussion with the former president R. Venkataraman. He said, why magisterial confession? How do you know what is being done to him before and what is being done to him after? How many of them know that if the man says, I don't want to make a confession, he has to be sent to judicial custody? But God knows what kind of a grip you have on the person. Now, of course, he may be a dreadful fellow. The only way you can get him to tell the truth may be coercion. All this may be possible. But nevertheless, coercion is coercion, and if you frown upon coercion, then there is no point letting in through the back door what you're unwilling to face. So the truth is that a person in custody is under a certain degree of coercion, even magisterial confession. Later people have said that this was the kind of threat used on us, and we were taken back into police custody. We had no means of saying no. So, a statement, if you believe in strict fairness, then a statement which a man is not willing to stand up and say, I plead guilty, in my opinion, that is the only statement that should be accepted. In fact, the lawyers that in warrants and sessions cases, even if a man stands up at the bar, magistrate is here, he will agree with me. Even if he says, in a serious case, I am guilty, the court is still entitled to say, no, we demand trial. Because it's not a personal right of his, the polity requires due process. So it's considered as inherent to the nation's interest, to the society's interest, there is due process. Looked at from that point of view, any self-incriminating statement, of course there are many self-incriminating things, fingerprints, voice samples, in Nandini Satpathy they said all this is not, but verbal self-incrimination saying I am guilty of this deed, unless the man is willing to stand by it at the trial. After what is big terrorist, dreaded terror, as soon as he hits the court station he says I have done everything. As soon as he goes to judicial custody he says it was coerced. What is the sanctity to such confession? This is an open secret, and we are dealing with this hypocrisy day in day out. That's why I said we have Indian judicial conscience has had a very uneasy. We are not fully willing to accept that violation. On the other hand, we sometimes wonder whether it's required. So this unease in society is reflected in judicial decisions.
Yeah, one last question.
Ma'am, you've accepted the fact, the uneasy relationship of the judiciary with the police. But ma'am,
No, not with the police. The police confession.
Yeah, police confessions. But ma'am, do you agree that many of these cases, right at the investigation process, due to this discrepancy, cause the accused who are not actually accused? For example, the Bombay blast case, there was a man falsely accused. There's a woman in Calcutta accused for his husband's murder, she was acquitted. So do you think that the police action now needs to be rectified, because this is leading to a phenomena where we simply do blame the police but nothing is being done against them?
So things are being done. So you're making very, very broad brush arguments. In any given situation with the best of intentions you may catch somebody wrong. On the other hand, you may catch the right person, but the requirements of law may not be met, so they may be acquitted on the benefit of the doubt. So there are various shades of this. If everybody the police catches has to be convicted, otherwise the police is wrong, that is also a very, very broad argument, because there is a judiciary to sift, and they may sift on various reasons. There is no doubt that there are wrongful arrests. It's also true that the police may bona fide believe that evidence leads to so and so, but eventually it may be established that that is not. So there are very, very shades, and something needs to be done is a very, very broad statement. Things are being done. After the judiciary does question them, even the trial court and magistrates court, at least in Delhi I can say, and elsewhere, they're bold in granting bail, in questioning things. Some things are being done, other things will need to be done. So it's not as though everything is dreadful and nothing is done. But things are often dark, and often you see light at the end of the tunnel. So no broad brush arguments can be made. But yes, I think investigative procedure definitely requires very fundamental overhauling. The superiors, more than the judiciary comes to later, the superiors must have a vested interest. Once you give the police an easy way out, they may avoid back-breaking investigation. Having said that, you must know that the police in this country is grossly overworked. The ordinary constable has dreadful, inhuman hours of work. So there are many aspects to this. It's not just that these guys are bad because they are bad. It's not like that. The police reform is at various levels. But it is true that investigative procedures in this country are not what they ought to be. The magistrates are very much overworked. Otherwise, the magistrate is supposed to check the case diary every time. But where? You know how many cases they had? So there's a huge overburden, and some of these are managerial problems which people must only, administrators must attend to them. I feel that they don't really attend to them.
We had one last question. Speak up.
Yeah, ma'am, I actually wanted to ask you, since you just said that it's difficult to always sort of pull the police up and.
No, I didn't say it's difficult to pull the police up. I think I sometimes not done.
Sure.
But it's difficult to always blame them, is what
Sure,
I'm saying.
sure. Very recently, Justice Deepak Mishra had said about the Akshardham case that to reward compensation for someone who had been wrongly held for whatever period of time would set a bad precedent. Now here is an opportunity to actually, I mean, sort of pointedly tell you that if you have been held wrongly, you can be compensated. So how does this set a bad precedent? And why?
See, many things I feel, for instance, now in the Criminal Procedure Code, it slightly may seem irrelevant to you, but I'm coming to your question. There is this provision for for judges to award compensation to the victim, section 357A. The end of the crime is not only punishing the guilty, but I feel that there should be a provision where automatically at the end of a case, the court should be able to see whether there is such an outrageously malicious prosecution that the victim can be compensated. Then it does not put an additional burden on the victim to seek compensation, and not in every case where there is an acquittal. See, there will be some case where it's a touch and go thing, but some cases are so blatantly absurd that courts have passed strictures, etc. In such cases, but there is one danger. Because a court which might otherwise be inclined to acquitt, once it realizes that it may also have to give additional reasons and compensation, may balk at it. I mean, this is a non-judicial consideration. I certainly don't see why people who have been held without any reason should not be compensated for loss of liberty, no matter what the case.
Right. Do you think that?
For instance, this woman, Navjot Sandhu, what business had they to keep her in custody at all? She gave birth to a child in custody. She has lost her mental balance. Who is to compensate? Money is not sufficient to compensate these things. There was really no reason to arrest her.
Right.
Whatever it is, I'm not commenting on the others. It's not a case for arrest at all.
But do you think tort law, if we had
a
better system, a more accessible system? I mean, for
See,
example, to pay court fees of the damages is a little bizarre. I mean, if
correct. That's why I am generally, whether it's in torture or whether it is in this, I'm personally opposed to more and more laws. I feel simplified procedure. Leave it to the court that is deciding the matter. If it thinks it's an outrageous prosecution, allow it to direct compensation to the victim. Because otherwise, what do we say? Torture. The person is already a victim. You burden them with additional litigation. They have to be at the mercy of lawyers. I tell you, it's perhaps better to be at the mercy of a policeman than be at the mercy of a lawyer. So, you simplify system. We tend to, more and more laws, nobody understands those laws, you write them badly, then you spend hours interpreting them. I would think that we should all try and simplify procedure.
Right, I think that's all we have time for today. Thank you very much,
Thank you for having me.
taking the time. Thanks, ma'am, taking me for gratitude at call for Nitya.
Oh wow, gifts also.
Thank you very much, ma'am.
Thank you for having me. Actually, I thought about it after so long, so many years. So the things started coming back to me as I was talking.
Thank you so much.
It was a tremendous learning experience for me. And we had very, very fine judges. Interested in the matter. Some little things came up, like the word discover. And Ramji, he said the word discover in section 27. I remember that happening. He said, when it was drafted, because there's this principle that you must look at, see, words acquire different meanings, etymology, things change. The words which meant something 100 years ago don't mean the same thing. Now they mean something more, something less. So the word discovery in section 27, he said in 1872, when the Evidence Act, He said in English, discover meant something which is conceived, to uncover. So something which is already known to the police cannot be discovered. That's also the law. Something new must come. But he said the word meant that. So it's not like you just find anything and that's discovery. You suddenly hit upon something, that's discovery. It's not like that. It is that something which is meant to be, which is known only to the accused, but through the agency of the accused you find out. That is why the term discovery is the only section which begins with a proviso. Perhaps in all of statutes. Section 27. So, there are interesting things like this. You'll find some reference to this in the judgment also. References, some and some observations here. It's very great. It's a great learning experience. Extreme, it was a remarkable experience. Thank you so much for having me talk about it and relive many of my memories which are actually deep buried.
Thank you. Thank you all for joining us this evening.
Thank you for sitting patiently, asking questions, which gave me to, at least it made me feel that you all didn't fall asleep.
We hope to see you all at Teacher Vidhi. Thank you.